Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about sexual assault. Cases that should have gone to the Supreme Court of Canada, but didn't. The case of Barton has a very storied history in Canadian law. It had previously gone all the way to the Supreme Court of Canada, a new trial had been ordered, that new trial was conducted, Mr. Barton was convicted, and the matter went to the Alberta Court of Appeal for a subsequent appeal. Unfortunately, that appeal was unsuccessful, and Mr. Barton sought leave to the Supreme Court of Canada, which was denied. One of the significant issues on the leave application to the Supreme Court of Canada was this question about whether or not the Alberta Court of Appeal had effectively created two different categories of consent for sexual assault. In Canadian law, consent for sexual assault must be ongoing. You must continue to give consent, and you must consent to every single instance of sexual activity. But the court in Barton ruled that consent can be vitiated before sexual activity even takes place if there is a reasonable, foreseeable possibility that serious bodily harm may ensue. And this obviously raises significant concerns because there are lots of instances of consensual sexual activity that do involve a risk of grievous bodily harm. Think, for example, of very basic things like shower sex, where it's reasonably foreseeable that somebody might slip and fall and bash their head on a tile floor. That's serious bodily injury, but it's not something that anybody would think is not the type of thing that a person could consent to. And so this sort of double standard exists in Canadian law when it comes to consent for sexual activity as a result of the Alberta Court of Appeal's decision. The Supreme Court of Canada had the opportunity to really narrow the focus of this issue to situations where the bodily harm itself was not within the scope of general sexual activity that people ordinarily engage in, and more within the scope of violence that wasn't anticipated or couldn't be anticipated in the context of a sexual encounter. And unfortunately, they took no opportunity to really clarify the law, setting up a serious situation for people who are engaged in sexual activity in circumstances where there may be a risk of bodily harm occurring. And if that can vitiate consent, that raises concerns about potential false charges of sexual assault being brought against individuals after an incident has taken place and when somebody decides that they no longer wished to have engaged in something that already happened. Because they can say that consent was vitiated because of simply the existence of a risk, that could lead to significant mischief in our criminal justice system. The Supreme Court of Canada could have guarded against that, and now unfortunately we're left in a situation where we have this strange situation in our legal system that is going to require another case to make it all the way to the Supreme Court of Canada to really iron out how these issues should be applied. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.